Well, good morning, good afternoon, good evening, whatever time zone you happen to be in. We're in for a treat. We are going to have a friendly conversation with the attorney that I'm sure everyone is aware of by now, but I'm hoping that I'm going to be able to have the chance to be able to get the chance for y'all to get to know him better. Our Australian lawyer, Bill Belisarius. And I believe I got that name right, and we'll check it when he gets here. And so less of me, the better. So I'd like now to bring on Attorney Bill, and we're going to have a friendly conversation, and I hope that you all enjoy it. So, Bill, would you like to say hello to everyone?
Yes. Hello, everybody. Hello, Scott. Thank you very much for allowing me this opportunity to have a discussion with you. Appreciate that very much. You're working hard late on a Friday. I'm actually at work today. I often work on Saturday mornings just to sort of do some catch up and try and finish before midday.
Well, and the time zone is not really all that challenging. We worked it out pretty effectively. And Bill, did I get your last name, the pronunciation correct? Is it Belisarius?
Well, that's just actually a pseudonym for Twitter. And Belisarius was actually a Roman general. One of my passions is ancient history, particularly Roman history. So I just use that on my Twitter for my Twitter address because I think one of the things I've even though I'm happy to make comments as a lawyer using my experience to shed light on developments in the case, and even though I do consider myself a member of the XRP community, I don't want to ever portray my own personal opinions as connected to the law firm in which I work. But it doesn't really matter, I suppose. My surname's actually Morgan, but I just use Belisarius because there's always a risk that someone will just take what you're saying as legal advice, no matter how many disclaimers you use. So that's the reason I didn't put it on my on my Twitter.
I understand completely. So for my benefit, I want to make sure that I state nothing that I ever say is to be taken as advice in any way. No financial advice, no lawyer advice, no advice, period. I'm just a person who is passionately in love with our XRP Army community, and I like to be able to bring interviews when I can get them, so we can all get to know each other better. Because sure. I think that when we know each other better, we're more willing to do things with each other. And the more we do together, I believe the bigger impact that we'll have. All right, so my disclaimer's over. So, Bill, first question, how did you find yourself moving into a profession as an attorney? So did you grow up with that idea from being a child? You just always had that as a dream of what you wanted to do as a profession?
Well, not initially. When I first left school, I actually worked in a bank for a couple of years. So one of the reasons I was attracted to XRP in the beginning, which the beginning for me was late November, early December 2020. I started to look at crypto. I was actually doing on a Saturday like this, I was doing an arbitration course. I'm now a member of the Chartered Institute of Arbitrators. So I did a full suite of arbitration courses to become a full member of the Chartered Institute of Arbitrators. And I had an all-day Saturday course, and there was a break for lunch, and I just didn't feel like going out of the office. So I started looking at Google, and I've been getting these pop-ups from CoinSpot, which is a local Australian exchange. And I think initially, the first coin I bought was actually Litecoin. I'm one of those people that didn't quite understand sort of the way you can fractionally own crypto at first. So I think at the time in Australian dollars, Bitcoin was about 20,000. I thought, look, I'm not going to buy one Bitcoin for 20,000, so I bought one Litecoin. But I was attracted to the description on CoinSpot of XRP, and having worked in a bank, I immediately understood what XRP was trying to do in terms of effectively doing what Swift does, but more efficiently, more cheaply, faster, and not only that, actually more safely, because SWIFT does suffer from frauds, and I don't think anyone's ever suggested the XRP ledger's been hacked. So it was a combination of those factors which quickly attracted me to XRP. And the other attraction at that point, I knew nothing about Ripple, so I'm one of the persons who fall in the category of knowing and buying the coin a long time before I really understood. Well, I shouldn't say a long time, but before I understood there was a company called Ripple and what it was doing in terms of ODL. So the other attraction was the Flare airdrop. So I bought, I first acquired XRP just before the Flare airdrop, and that was also one of the reasons, as well as its use case. And then I had the experience of the lawsuit dropping 10 days later, I think it was, and having my first dump, my first experience of a dump. But I believed in the use case from the beginning, and I still do. And I think that, lawsuits eventually finish. And so I've never really had any doubt about keeping the XRP I have. I don't look, it's not a life changer for me if it goes from, I think it's 61 cents at the moment, which is incredible. But I don't own so much that if it went from 60 cents to $2, it's going to change my life. But I still believe in it, and I want to hold it for a long time on a long-term basis.
Well, and so when you first looked at it, how long did it take you to be able to look into Ripple? And when you looked at Ripple, the company, eventually, what were your impressions of the company?
Well, I found out about Ripple from the lawsuit because I inquired into why the price had dropped, and that's how I found out about Ripple. And I struggled conceptually with the notion intuitively from the beginning that a crypto can be a security. I mean, I think in Australia, although we don't have a regulatory system yet for crypto, I don't think anything's been looked at in Australia as a security. And I know that one of the proposals from a recent Australian Senate review committee was there was a number of recommendations, and one of the recommendations was to engage in a token mapping exercise with a view to, when legislation is passed, which may be next year, of actually classifying cryptos according to their economic reality. And if one looks at the submissions that were made to that Senate review committee, including submissions made by Ripple, and those submissions were obviously meaningful because some of Ripple's submissions were actually extracted and quoted in the report that was produced following that Senate committee review. It's apparent that the people behind in the Senate committee are already looking at XRP as a payment token or an exchange token based on its underlying economic reality, rather than as a security token.
So, Bill, that was one of the things I also wanted to ask you. Since you're in another country, the only experience that I have with XRP is what the American regulators have been doing, excuse me, and the exchanges here. So is there, being in Australia and being an attorney, is the access to XRP limited in any way due to the lawsuit in Australia?
Not at all. Not at all. I can go onto any Australian exchange and buy XRP.
And do you see any development of the ecosystem by companies in Australia that are building out the ecosystem?
Look, I think that I can't name them, but I have seen some articles where there are some Australian companies involved in remittances or money transfer that are relying on XRP or are using XRP.
Okay, and So I've heard that America is basically the only country in the world that seems to have any issue at all with XRP. And as far as you know, are there any other jurisdictions on the planet besides the United States that are doing what the SEC is doing?
No, there's no other countries that I'm aware of, but then there's no other countries anchored. I think I have to use that word by the Howey test. There is a concept in Australia in securities law of a managed investment scheme, and the notion is that anything can be marketed and sold as a security. And just I think John Deaton has said that about any asset can be can be brought within the Howey test if it's marketed and sold as a security. But they're not quite the same terms. The managed investment scheme is a sort of creature. It's a statutory definition. It's not a case law test. It's a statute based test. So it's not exactly comparing apples with apples. And I'm not a securities lawyer anyway. I actually practice in trade practices and consumer law. But as far as I can ascertain, they're not direct. There's no direct equivalent in Australia to the Howey test.
Gotcha. And so since we're talking about the case, we had a development, I believe today, something to do with the scheduling. Is that what happened today? I briefly saw Mr. Filan put something out today. And I think it had to do something with the scheduling of the summary judgment. Did I get that part right?
The last thread of James I looked at was talking about the likely or whether, looking at the issue about whether there could be judgment this year on summary judgment motions. And he gave some fairly cogent reasoning as to why that was more likely to be in early 2023, with which I agreed. Although it could possibly be before Christmas. I think at the moment we're waiting to see whether the SEC files its motion in relation to attorney-client privilege over the 68 speech documents and the issue of redactions. And that at the start of this interview, that still had not been filed. I'm not sure what time it is now, but they have till midnight your time, so it may have been filed by now.
And in your experience, I guess I kind of am asking you to kind of handicap it. Do you feel like, based on the way that Judge Netburn and Judge Torres have been making decisions, do you think that they're going to try and make the SEC deliver those emails, or do you think they're going to fall in favor of the SEC and keep them from everybody?
Well, I think there's two things I'd say about the SEC's conduct in relation to the 68 emails, or maybe three things. One is it's really not ordinary for a party to go to this extent to not disclose documents unless there is something in those documents that's difficult for the SEC's case. And I was one of the first people, I think, that started to say that there must be something there. If you go back and look at my tweets. The second thing is that parties do have a right to exhaust their rights. So if there's avenues to object or appeal, you're entitled to pursue those avenues, and it may cause a delay, but you're still entitled to do it. And the judges have to deal with each request or objection or appeal on its merits, because they have to be fair to both parties. That's what you expect from judges, and that's what they should be doing according to their judicial oath. But then the third thing I would say is that the extent to which the SEC as a plaintiff has delayed this matter itself is unusual. It's usually not a good sign when a plaintiff is delaying a matter and not taking it to trial. And you can speculate why that's so, whether there's always been a problem with the lawsuit being rushed and the SEC not having the evidence they'd like to take it to trial. It's just quite odd, I would say, to see a plaintiff engaging in delay to the extent the SEC has.
Well, do you believe that might be in part that? Well, see, it doesn't make any sense to me either, because Ripple's got deep enough pockets that I think they can continue to pay for their legal team. But I think other companies that they might not have been able to withstand the time that this took. And maybe they're trying to send a message to other companies that if you get involved with this, you better be prepared to go through a long, time period. And a lot of other companies, I don't think, have the war chest or the legal team to be able to withstand it.
Yeah, I understand that argument, but at the same time, the longer it goes, the more it gives a blueprint for other crypto-based companies to defend an action. So I think that cuts both ways. And there's a in terms of ultimately losing, it does have serious consequences for the SEC, and I've referred to them in some of my Twitter threads on why I think this is a good time for the matter to settle. Because, when you lose a big case, you lose big. Ultimately, if matters go to trial, there's usually a big winner and a big loser. So that's why so many matters settle, because of the catastrophic consequences of losing.
Well, if you, this is one of the things that I always like to ask Attorney Hogan whenever he does one of his videos, or we see a new decision by one of the judges, is, well, if you were Attorney, what is his name? Not Cisneros, but the guy who's in charge. I think he's the lead attorney for the SEC. If you were in their shoes, would you feel very confident right now that you've got a good case that you feel like you can win? And Attorney Hogan usually comes back with the same response every time. He says he would punt. Don't know if that's a legal term, but he's pretty consistent. I don't think Jeremy feels like the case is going very well from the SEC side. But if you were in the SEC shoes, would you feel like that you had them and you just wanted to carry this out as far as you could and get it to a trial?
Well, this is a difficulty with even answering that question, let alone the question about who I think will win or lose the ultimate case, is that I haven't seen any evidence. And I say, even when I act for clients and they ask me, do you think I will win? You give an advice that would be highly qualified, and you wouldn't want to give the advice before you've seen the evidence of both parties. So it's just not particularly meaningful until you've seen the evidence to even to speculate who's going to win or lose, because it's just pure speculation. So even on individual issues, like I have some real questions about the SEC and the common enterprise prong of the Howey test, which I've tweeted about. And to me, it seems a real stretch. And there's not much, like, am I in a common enterprise at Ripple when I bought XRP in December 2020 off an existing secondary exchange in Australia, not even knowing if the company existed or what its role was? To me, it just seems a very long stretch. I just don't know if the test is that elastic. And I did share an article on Twitter recently by the attorneys Kershit and Morse, and some particular comments they made about the effect of the SEC emphasizing common over enterprise. And they had some doubts about the common enterprise prong of the Howey test. And it's something that John Deaton has pointed out, that Mr. Gensler refuses to he doesn't refer to it. He fails or refuses to refer to it, and it's very incoherently set out in the SEC's amended complaint. So I'm not an expert in securities law, and I don't practice in the US. So before this case, I didn't even know there was such a thing as a Howey test. But what I do is a lot of pleadings. We call them statements of claim, but it's essentially the same thing as the SEC's amended complaint. And it was a surprise to me when I read the amended complaint, looking at that particular issue of the common enterprise, to see it really incoherently pleaded. And that drew my attention to whether it's a lurking problem for the SEC. So I don't know what evidence the SEC has on, or what they're going to rely on to try and prove there's a common enterprise. But it's just noticeable that they haven't set it out very clearly what it is. They seem to say the common enterprise is either Ripple creating secondary markets, or which already exist now. So even if that was true once, it's hardly a common enterprise that needs to continue, because there's the only thing that interfere with the secondary markets is the impact of the SEC lawsuit in the US, because everywhere else XRP is freely traded, so those secondary markets are intact. Well, the other thing that the SEC may be referring to with common enterprise is building out ADL and increasing liquidity. But I struggle with that concept too, because the natural parties that Ripple are involved with are not people who buy XRP on the secondary market. It's the exchanges themselves or market makers. So, and ADL's like a product or a software. I mean, whatever you want to call it, it's not the same thing as XRP. And many people have commented since this matter commenced that XRP will continue to function. XRP ledger will continue to function regardless of Ripple. And conversely, Ripple doesn't necessarily need to use XRP for on-demand liquidity. It uses it because it's the best crypto for that purpose. So I really do struggle with the common enterprise prong of Howey. I've read the Howey case and some of the other cases. I really struggle with the notion I'm in a common enterprise with a company I didn't know about when I acquired XRP, for which I have no contractual relationship, that I have no rights from Ripple as an XRP holder. It seems a really big stretch to me.
Yeah, I made my first purchase of XRP in January 2018. And I'm like you, Bill. I had no idea what Ripple was. I had no clue at all. I just saw some videos, and the people didn't talk about Ripple. They talked about XRP, and they talked about it being a bridge in cross-border payments. And that just kind of seemed to make sense to me, because I agree with you. A 3-second float is a lot better than what we've got with Swift over a 3 to 4 day float. A lot of bad things can happen in 3 to 4 days. So not all that much can happen in 3 or 4 seconds. And like you had said earlier, I've never heard of any hack on the XRP ledger. So I think it sounds like a pretty good upgrade from Swift. Do you feel like that? Have you heard any of the rumors, the Tin Hattie kind of stuff, that the IMF could possibly take the escrow and then pass out XRP sort of in a great reset, debt jubilee scenario, and hand it out to the members of the IMF, and that they use that as the currency?
I haven't. I've heard of it, but I don't. It doesn't impress me as a possibility. I don't think there's enough value in XRP for that to be meaningful at the moment.
Well, I think the theory, and again, I'm not saying that I believe that it's going to happen that way or not, but they would take the 50 billion, pass it out to the members of the IMF, and then put the value on it. And that would be enough in the theory that it would basically bail the countries out of their debt that they're in and start using XRP, say $1,000 in XRP. And again, I'm not saying I'm a proponent of it. I just know that that's one of the theories out there that's being floated, is that the IMF could actually get the escrow from Ripple and then use it in that fashion.
Yeah, look, there's a lot of theories. It doesn't impress me, that one. And there's a lot of theories about why SEC brought the case as well. And
yep.
Sometimes the most simple answer is the one that's correct. The SEC will pick its time, and I think now's a good time for settlement discussions to get what it can in terms of a fine. I mean, tens of millions, hundreds of millions of dollars is meaningful for a regulator because they have limited budgets.
Right. Yeah, I'm a big fan of Occam's razor as well, and usually the most simple, obvious answer is usually correct. Do you feel like that the SEC would be willing to be able to declare, if they got, a big enough settlement, do you feel like that they'd be willing to declare that XRP was not a security?
They could make that declaration in a settlement. I'm not sure the legal effect of it. At the end of the day, law is made not by regulators; it's made by either judges or legislatures. So I'm not sure what legal standing that declaration has. I just don't know enough about the SEC to know whether it has a sort of delegated power to make a rule, and that has the force of the force of statute in terms of a regulation or a rule. But you can agree to anything in a settlement. I mean, if you can put it in writing, you can agree to it. And I can't understand, based on my knowledge from another jurisdiction, why you couldn't get clarity that way.
Well, I think, and again, I'm obviously not an attorney, but I think setting that precedent where other companies could refer to the settlement and refer to XRP not being a security, and then they would go with them and say, well, if they are, how come we aren't? Or we are or aren't? So I think it's that precedent that other companies might use, even though it's not law. And then again, Congress could come in and make a law, and that, I believe, would supersede what happened in the ruling in this case. I think that's how it works. So do you have any other speculation at all, Bill, about what you feel like could be the sticking points on either side in a settlement?
I guess it's the political motives, if there are any, for the SEC to bring the case, because a lot of the reasoning that I shared on Twitter about why this is a good time to settle is simply invalidated if there's just another motive for the SEC to continue this matter to the end, to summary judgment or a trial. And if this case is caught up in a turf battle between the SEC and other regulators, then that can sort of hinder or stop a settlement. But then again, a loss is not good either for the SEC in terms of, if it wants to carve out more jurisdiction in securities, in relation to crypto.
Right. Well, one of the things that I'd asked Mr. Filan today, I didn't have time to check Twitter to see if he answered me or not. And I don't know if y'all are getting a chance to see any of it, but it is a tremendous train wreck. But we have Johnny Depp and his ex-wife, Miss Heard, are in a lawsuit, and the trial is all televised. we used to have a lot of trials televised, and then with court TV, and then it kind of fell off. But this one is televised. And I asked Attorney Filan earlier today on Twitter if this case, when the trial opens up, is that going to be something that anybody is going to be able to see, or are reporters going to be able to go in and listen to it and then take their notes and then be able to report on the day's happenings if we can't actually see it? Or is everything going to be kind of closed up, sort of the way that it is right now?
Well, I mean, in Australia, trials are always public. There are some exceptions, to do with children and some other exceptions, but they're generally always public. Televised is a different issue, so they can be, they're normally public and not televised. I don't think the practice of televising cases is prevalent in Australia as it is in the US, but I just don't know enough about whether there's rules behind that in the US, whether it's just a matter of some party applying to the judge, or there's rules that affect whether it can happen or not. So one of the difficulties of following the case is the difference in rules. So I don't know the rules of court under which this litigation is being conducted, although they're the same sort of processes as that I practice under my rules are the Uniform Civil Procedure Rules, which is applicable to the Supreme Court of Queensland. So most of the processes, apart from the pre-trial depositional questioning, are similar to my rules, but there's a difference in timing in the life of the proceeding about when some procedures happen. There's a difference about emphasis. I think there's a difference about whether things are as of right or not. Like in the Supreme Court of Queensland, I can't just issue interrogatories under the rules. I need the leave of the court. So once upon a time you could issue interrogatories, but now you need the leave of the court, and it's a little bit restricted whether you can, where it was a big step in this matter. So it's like speaking English with an American. You can follow the language, but there are just different slang words and different nuances and emphases, and you can just miss a subtlety or a shade of meaning. So that's what the difficulty I have sometimes in interpreting things.
And if you and I know so much of what we're involved in right now is speculation, because we really don't have that much access to any evidence. But in America, in our American baseball, we have 9 innings. And based on what you've seen so far, where would you say, as far as innings go, that we are in this case? I mean, are we still in the 3rd inning? Are we? And I know that the trump card is that a settlement could come basically at any time, whenever they decide to agree on it. But do you feel like that we're halfway through this based on your legal experience, or are we farther than that, or what?
Well, if for me in matters I practice, if you've got your expert evidence finished, which it is in this matter, I think, apart from the response that Ripple can make to Dr. Metz, the leave they were given to further question him and to put in a supplemental report. The expert evidence is finished. The discovery is finished. Interrogatories have been answered, I think, as far as I know. So I would say that when a matter reaches that point, for me, in my practice, that it's ready for trial, and I'm giving the other parties a request for trial date, and if they don't sign it, I apply to the court to get it dispensed with and the matter set down for trial. Now, the big difference here is that we can bring summary judgment applications under our rules in Queensland, but you tend to bring them early in the proceeding you're going to argue that there's simply a bit like the motion to dismiss, that there's just not a maintainable case or a maintainable defence. We don't have a stage where you bring a summary judgment at this point, this late in the matter, after all the evidence is finished. You just move on to trial. So maybe it's not. it feels to me like it's close to being finished, based on the rules under which I practice, but it may have a little bit more to go, because of that summary judgment stage being, at this point in this proceeding, not earlier. But I think procedurally it's gone well for Ripple. For a defendant to have had as many significant wins as it has had to now, particularly in relation to disclosure, it is normally a really good sign for a defendant, particularly when the plaintiff's opposing it so much and losing.
Well, and I may be incorrect in this, but I think from what I remember that the SEC has said no to turning these emails and email drafts over. I think 4 times. Maybe it was 3. But have you experienced in your law practice and in your trials and cases that people have said basically no to the judge that many times?
No, not from a plaintiff.
That's one of the things that I just don't understand, why the SEC feels like that they can disrespect the judge's order to turn the emails over.
Yeah, I don't think they're disrespecting it. They're just exercising every right they possibly can. And that's causing it to be delayed. And the question is not, can they do it? They can. They're doing it under the rules. The question is, why are they doing it?
Well, and I think you and I would both be feeling fairly safe if we both speculated that there is something in there that they don't want to turn over.
Yeah, well, it's hard to draw any other inference, really. I mean, they could. Another possibility is that there's nothing there, but they've sort of taking Ripple down a dry gully, knowing that they can then. It's adding to the delay in the proceeding, but that still comes under the umbrella about why are they delaying. So it just begs the question anyway: why are they delaying to this extent? It's really odd. It's just not normal for a plaintiff to delay like this.
Well, and I think one of the things too, why did they even bring it in the first place? And one of the things that I've learned from listening to Attorney Deaton and Hogan is that there is a bit of a human factor that even if the judges try not to think about it, but the fact that John came and added and got himself added into the case, and you feel like that was significant that John was able to put together 66,000 people and a lot of them are coming in and saying, hey, we didn't know anything about any kind of Ripple company. All we saw on the exchange was this token XRP that we bought. And do you feel like that it has a bigger impact to the judge when she sees that there are 66,000 people, U.S. citizens and other people from across the globe, that have all said, look, we haven't been protected by by this SEC action. We've actually been harmed.
Well, it's extraordinary that it's ever come about that there's a community that has 66,000 people, or it's nearly 67,000 now that have been granted through John amicus status, and they're the people that the SEC is meant to be protecting. It's just hard to grapple with. I've just never seen anything like it from Australian regulators where there's been that sort of public backlash against a case. Usually regulators bring cases against people who deserve to have cases brought against them because fraudulent conduct or misleading conduct, or they're just harming consumers by contravening securities legislation. But what's the evidence that anyone was harmed? It does go back to what's the motive for bringing the action.
Well, I think there's a good rabbit hole we could go down there about the fact that maybe they were giving Ethereum a free pass, and Clayton and Hinman all were kind of doing that, but we won't go there. But I
Well,
think that there is something if people wanted to open that up. I think DAI has been doing a pretty good job of sharing with people a potential
yeah.
motive for why they did what they did.
Well, one thing's for sure, it would have been very unexpected, I think, on the part of the SEC for it to have ever come about that there's 67,000 almost XRP holders who have amicus status, and that's because people like John Deaton don't come along every day. It's an extraordinary feat that he has achieved in galvanizing the community and being able to obtain amicus standing. If he hadn't have been there, if he hadn't have cared and done, there's no reason anybody else would have done it. Sometimes one person makes a difference, and what he does is really extraordinary to me, because I know how hard it is to run a legal practice and how much additional work he does for the XRP community and in the case as the attorney for those people that have amicus standing is really extraordinary, and all the other things he set up to for access to Congress, even for international people like me, and I did utilize that tool to get my point across. They're extraordinary feats. There's no doubt about that.
Well, one of the in the time that I've been involved in our community, being able to have met John in person, I went to the SEC protest that we had in Washington D.C. and was able to meet John in person. And I've my professional work is I've been a salesman coming up on 4 decades now, and I'm not generally intimidated by speaking to other people. I mean, basically, that's what I've got to be able to be pretty good at that, or I'm not going to be able to make any money. And when I first met John, I stumbled over my words. And what we've done with our channel and trying our work in the community is what we've done is tried to put together people in the community to ask for John to be able to get interviews together, because we feel like, hey, if almost 67,000 people signed up for the case, that's more powerful than if 10 did. And if close to 67,000 people were asking John to be interviewed to whoever it is that we're trying to get the interview from, more likely that's going to happen in that fashion as well. So that's what we've been trying to do on our end with our efforts, is to bring our community together to try to see how many interviews we can get for John as possible. So,
yeah. And that's another thing John does too. He shares a lot of his time doing interviews and being in videos, and he's always very impressive. It's an overused term, but I think he's a great man.
Yeah, well, he's one of my greatest heroes. And again, my bucket list to have been able to meet him in person. And you were on my bucket list because I've been noticing you, Bill, and the different comments that you've been making on the case so far. And it's, I told you before we started the interview, I was able to spend 10 days at the Gold Coast one time. And I'm from the South. We got a lot of friendly people here, but the Australian people were just overwhelmingly kind and engaging, and a lot of the women were really pretty. I don't know if it's obvious or not, but I'm a man.
I think the feeling's mutual. I think most Australians, love Americans when they meet them as well.
Yeah. Well, so
the politics can be a bit confusing sometimes.
Yeah, a little bit, but our we don't go into politics much on our channel, but I'll just say this: I don't see how much more messed up it could kind of get in America right now. So come on November. and we're going to try to do as much as we can to find politicians who are pro crypto, and see what we can do in that area to see how we can support those people and get the word out about pro crypto politicians, because we really need our government to come in line with getting behind this, because I don't think there's another country that took more advantage of the .com boom than America did. When we got Google, we got Amazon, we got PayPal. We did pretty good in the global expansion of .com. And if we keep messing around, we're going to let places like Japan and Singapore and England take the lead in the blockchain boom.
Yeah, well, I think that there is that risk in it, and that's a risk Brad Garlinghouse ceasingly refers to. The flight offshore from America of innovation, when you have the SEC behaving this way, it's certainly a chip in the wall I'd keep beating away at if I was in Brad's shoes.
Yeah, I believe I would too. And, I just, as a lifelong American and a North Carolina resident, all but 2 of those years, I love my country. And we have the opportunity with the innovators and the entrepreneurs and the tech group. We've got an opportunity to be able to take a good bit of the blockchain slice of the pie if we get it together. So I'm hoping that we're going to be able to do that. Okay, so Bill, as we wrap up, is there anything basically that you would like to say to our XRP Army community about yourself or about the case, or anything else that I failed to ask you? Is there anything that you would like to say in closing?
Well, I think what I'd say in closing is that I think that the lawsuit's unfair. I think it's particularly unjust on American investors who are shut out from, with a couple of exceptions, from XRP. I don't like the injustice of it. That's why I have started to get more involved and comment more. If that provides some assistance to people, because people are subject to FUD and that affecting their decision making. So if I can, to some extent, at least have another perspective that's more positive, then I like to share it, because the injustice of it really makes me angry. And so when I get my teeth into something that I think is unjust, I usually don't let go. And I would just say that I hope that the people, they make their decisions based on fundamentals and not FUD. And I think the lawsuit's obviously important. It's not FUD, it's a fact. Ripple has to go through it. But I think people just need to keep their eye on it and listen to what, follow it, not just listen to the FUD about the law case as well, but listen to the perspectives of other people, including the attorneys. But also, people have really good perspectives. You don't need to be a lawyer to have a good perspective about the case. So it's a really tight community. I came to XRP first and the community second, but I feel really good about being in the XRP community, because I think it's a very strong community, and it'll be extremely strong after this is all finished. Because the old saying, "What doesn't kill you makes you stronger."
Yeah, I agree. I think we've got the greatest digital asset ever created. I think that we've got the greatest attorneys in our community that have ever been created. I also think that we've got the greatest YouTubers and influencers ever created. And my mission, until they put me 6 feet under, is to try to bring us all closer together, because I believe the closer we become, the more that we message together, the stronger that we are. So, all right. So I know I'm going to say goodbye, and Bill, we'll stay on for just a second. So
can I just get one?
Yeah, go ahead.
One thing we didn't mention, I just wanted to give a shout out to some of the YouTube presenters like Moon Lambo and Mickle and Frank Chow, they all follow the case, and I think they do a tremendous job of putting it very plainly in good plain English, very concise summaries of what's going on in the case. I think they do a tremendous job and service to the community as well.
Yeah, I don't. The reason I don't do news videos is I usually don't play if I know there's no way that I'm going to be able to win. And there's no way, Bill, that I am going to try to compete with our influencers and try to do news videos and commentary videos, because we've already got the best in the business and I'm not going to be better than them. No. So what I try to do is tell stories of people in the community and do interviews when I'm honored enough to be able to get them, like with you. And I deeply appreciate you taking the time to do this with me. And I think
thanks, Scott. It's been very good experience.
I think people are really going to like hearing from you.
Thanks, Scott.